And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shaw Pirelli for the Shaw Pirelli Law Show, coming at you with over 50,000 watts of power. The Shaw Pirelli Law Show, where all your views matter.
Hello, everybody. Assalamu alaikum, Sastikal, Namaskar to all the listeners. This is Attorney Shaw Pirelli, and I wish you happy July. We are July 19th today, and we are live on air on Radio Zindagi, and I have with me today my good friend Michael. Thank you, Michael, for putting things together for us. And we are going to discuss, of course, about immigration law, two important memos that we really want to discuss about, and of course about other issues on immigration. And before I start, anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And the number to the studio today is 510-657-1170. 510-657-1170. Let us start. We have two memos. Last week, I don't know if I discussed the other memo, but I'm going to discuss both of them. But one memo which came in on June 29th, where basically we have this situation now, people are going to be placed on an NTA. That means deportation if their cases are denied and if their visas have expired. And the other change on that is that this NTA will be issued directly by the USCIS officer, which is not usually the case, and that's another change, which means basically as soon as the officer denies your case and he sees you are out of status, that means your case has already been, your previous I-94 has expired, etc., you might get an NTA. What it entails is very, very bad, because once you get that, you will have no choice than to appear in court, either to fight your case or to ask for what we call a voluntary departure. That means you cannot just leave the country right away. So I just want callers to wait a little bit. I'm going to discuss that, and then I'll start taking callers, Michael. Just tell them to be please patient, and because these are very, very important issues I wanted to discuss. So what will happen, and based on that memo, we are going to see a bunch of cases that are denied or referred to the court. That will complicate your situation, because the court is overwhelmed, and you might not get an appointment in front of a judge until 2-3 months down the road. And in the meantime, you'll be left hanging in limbo. And then if within 1 year you don't depart, after that, if you get a voluntary departure, you will be accruing unlawful presence, which will bar you to come back, etc. Now, there's a second memo which hit us really hard on July 13th. Now, they are going to deny cases if they feel like without an RFE or notice of intent to deny. What it means is that it doesn't even give you a chance to respond. So, for example, you file a case. What happens to you if there's no RFE? You don't even know where they're coming, and suddenly you just get hit with a denial. When you add those two memos, you have a denial, you don't have an I-94, and you have the previous memo. What happens to you? You can be placed in deportation. This is really, really unfair and really, really bad. I'm hoping that there will be some fight against it, but until then, you need to take your precautions, and I'll talk about that in a little. Let me take one caller, Michael. I think Suresh is there. Hi, Suresh. Hello?
Hi.
Hi, Suresh. Can you hear me?
Yeah, I can hear you, Shah. Hi,
yes,
good morning.
Go ahead. Good morning.
So, basically, the question I have is I have this I-94 that is expiring in September, but right now I am in pending adjustment of status for the 485, and I'm working on EAD right now. I don't have a H1 anymore, so working on EAD, and this is due. So, whether I should renew the I-94 or what is the step that I need to take right now?
It is not necessary. You're talking about the I-94 and H1B, right?
Yeah.
Okay. Yeah, it's not necessary, because what you have right now is called a period of stay authorized by the Attorney General, and you have an EAD. However, If you have other issues like your spouse doesn't have your wife doesn't have an EAD like you, then it's good to keep your H1 so that she keeps her H4. Or if you feel like there's some kind of issues on your case regarding the I-485, for example, a criminal background, etc., it's good to keep the I-94. But it's not necessary to do that. You are still eligible to stay under INA 245A, which means basically you are in a period of stay authorized by the Attorney General. So you don't have to renew it really, but right now, if you can renew it, go ahead and do it. If you can, you're fine too. Okay?
Okay. So basically, we both are on EAD right now, so no need to renew.
So it's not necessary to renew the H1. But to be on the safe side, if you feel like there's some kind of issues with your I-485 that can come up, then it's a good idea to renew it. But the good thing is that if something goes wrong, you can always go outside and revive the H1 if your I-140 is still there.
Yeah, but the
I-94, no, it's not necessary.
Yeah, the I-94 still is not required to be renewed or anything, right? I-94 that is on H1.
You don't have to renew it because you have the period of stay authorized by the Attorney General through the INA 245A, and you also have an EAD you can work with, so it's not necessary. Okay?
Okay, right. Thank you so much.
Okay, good luck to you. Let me take another caller. Hello?
Hello.
Raja?
Hello.
Hi, Raja.
Hi,
Hello.
Mr. Shah, how are you?
I'm doing well, sir. I'm doing well. What can I do for you?
Sir, first of all, I have been a regular listener, and your show has been very informative, so congratulations on all that.
Oh, thank you so much. Well, you guys make it successful, so I really appreciate it.
Okay, I am actually on H4 EAD, and I have a two-part question for you. The first thing is that is it recommended that my wife and we both apply for a premium renewal? We are due for a renewal this September.
Okay, you mean your wife will apply on H1 and you are applying on H4, right?
Yeah.
Yeah, the thing is that there's no real premium for H4. However, it is recommended when you file the H1, file the H4 and the EAD together. And then sometimes, as a matter of courtesy, what they do, they will premium it. But just bad news is that in the past 2 months, I have not seen them really premium, basically kind of processing the H4 expeditiously like they have done for the H1. So even you do that, there's no guarantee they will do it together because there's no law that premiums H4. However, yes, I would recommend doing all of them together. Okay?
Okay. So what you're saying is that there is a chance that the H1 result would come first and the H4 EAD would take more time?
Yes, and that's what's happening in most cases. Yes.
Okay. All right. And the second question is there a process that my employer can keep me on without the EAD? Is there a process that employer can apply for my another kind of visa or something?
Well, they will have to go on H1B. There are not many other options. There's also the J1, and I'm not recommending anybody to go on F1 CPT. So, unfortunately, there are not many options once this is gone. If the H4 EAD is gone, the option is more like case by case, but there are not many anymore. So I hope they are not going to take it because the H4. I'll talk about that in a little bit, but give me a call and then we can assess your case in particular. I can't do it on the radio, but I can talk to you about some options that might be available. Okay?
Okay. All right. Okay. Got it. I'll contact with you maybe personally on my case and maybe we can see where we go.
Because it's very hard to kind of give a full assessment in 1 minute or two. But the number to my office is 510-742-5887. Okay? Good luck to you.
Right.
Okay?
Thank you, Mr. Shah. Have a nice day.
You're welcome. Thank you so much for your kind words. I think we have another couple of callers, right? This is Shah Raleigh. You're live on air. Hello? Hello? Rashmi?
Hello?
Yes, hi.
Hello?
Hello? Can you hear me?
Yeah, hi. Can you hear me?
Yes, I can hear you very well. Go ahead.
Yeah. My name is Rashmi, and I a question regarding the H-1B stamping. Basically, we have an approved visa, H-1B visa till 2021, but we need to go to our home country, and for that, and when we return, we need to get it stamped. So, with these new rules which have come up, do you think, like at the time of stamping at the embassy, consulate also, they can deny that?
Yeah, you never know. But those two rules I was mentioning earlier doesn't really affect that. However, there are many other conditions that is kind of particular to each case. For example, if your company is not a strong company, or you're working for a third-party client and they have not proven the link, etc. So yes, it is becoming more difficult. Having said that, most people are still getting their stamp, so it's not like everybody is getting denied. It's only becoming a little bit more difficult, and just make sure that you have a letter of employment, you have all your check stubs, etc., etc. Almost like reproving the entire case with you when you go, then you should be okay. If your company doesn't have a good track record, then you might be facing some difficulties, okay? All right?
Okay, that's all.
Okay. Good luck to you.
Thanks a lot.
Good luck. If you need help, just give us a call, 510-742-5887. Let me take a caller, Michael. Hi, Rajesh. Hello.
Hello.
Hi, Rajesh. How are you?
I'm doing good, sir. How are you?
I'm doing well. What can I do for you?
So I just have a question about EB1.
Mm-hmm.
For India, so is this the best way to get a green card based on employment?
Yes. Yes, right now. Not only for India, for many people around the world, because it goes the fastest. Although it's retrogressed right now, it's still better than EB2 or even EB3. So, yes, the only issue is, do you qualify for it? There are three kinds of EB1. You have EB1A for people of extraordinary ability, EB1B for outstanding professors and researchers, and EB1C for intra-transfer employees, like you come as an executive or a manager. So it all depends which one you're picking. The EB1C is usually the one most people pick. The problem is that you have to be working in the past 3 years for 1 year in the company abroad. Number two, you have to be either an executive or in a managerial capacity. And number three, you have to be brought by a qualifying relationship company. That means either a branch, a subsidiary, or an affiliate. So it's still the best. I do a lot of EB1 lately, and we're very proud to say I think most of them.
So my question was for EB1A. If you apply it now, how long will it take to get the green card?
It all depends, because right now it's 2012, so we are talking 6 years. However, we think it will go back to current, maybe, we think, I might be wrong, around October. And also a lot of people have already EB2 locked in on an earlier priority date, so you can transfer that priority date also. So right now it will, according to the dates, it will take like 6 years. But I think personally that it will shorten soon, and people will get it within like 2-3 years. But compared to EB2 and EB3, it's still a better deal. Plus, EB1A, you don't have to go through a labor certification. And the second thing, you don't even need an employer for that. That's the beauty of EB1A. You're welcome. Okay? So you can call us if you need any help, 510-742-5887. I went long on the EB1A because I get very excited. I really love this visa because it's one of the best visa we have right now, and national interest waiver also. So let me go back now. I don't think we have more callers, but feel free to call 510-657-1170, 510-657-1170. And that's the studio number, and for our office, 510-742-5887. Once I start speaking of EB1A, I don't want to let go. So let me now go back to our biggest issue we have. It's the issue of those two memos. Those two memos are like the twin peaks of problems, right? Because a lot of people will notice that there is an extensive number of denials coming, and if you get denial and you are out of status, they might send you what we call a notice of intent to appear, notice to appear. What am I saying? Notice to appear, an NTA. And what this does, you'll have to go in front of a judge in order to leave the country. And some people told me, well, if I get the NTA, if I just leave, what happens next? What happens is that your case continues. Then you will be placed, since you're going to be on a no-show, you're going to be issued what we call a deportation in absentia. What that means is that they deported you while you were not present. And the next thing that happens, if this happens, you will be blocked for usually 10 years not to come back. So be very careful, and I'll give some tips about how to deal with that, but let me take another caller and then I'll talk about that. This is Shapra, you're live in here. This is Shapra.
Hey, Shah. This is Shailesh. Hey, thanks for taking the call.
Thank you, sir.
Hey, I have I just have two questions. So one of the things is basically I'm an H1 and my wife is an H4. And the thing is, my wife's H4 expires like in June 2019. But you know, when I was doing this, I changed my job, and my new H1 expires in February 2020. So what I understand is I can only apply like H1 6 months before that, right? So in this case, do you think I have to apply for my wife's H4 like 2 times next year, considering it is still there?
Yes. There's nothing wrong to apply first, get an extension, then after you do your extension, you do another one. But of course, it's if you can match it to do only one, you're fine. But you can't, because you cannot apply for your H1 like you said until you're 180 days from the extension. However, if you do a transfer or something, when you let me ask you a question. When you transferred your H1B, did you transfer the H4 for your wife?
Yes.
Okay, fine then. Okay, that's what so if you move, let's say now to company C, you can always file an extension for her together with your H1. Okay.
Right. So my question is, but with the current situation and assuming the H4 still is there next year, then if I want to, like, you know, first I need to apply her for till 2020, and then I have to apply again till my new H1 goes, right?
Yes.
Okay, but only thing, in case if I change a job...
Only 1 year. I'm sorry?
Yeah, only thing in between, in case if I change my job, then I will get a new end date, and in that case, I need to only apply an H1 once, like a EAD only once, right?
Yeah. EAD you don't have to reapply. You can only apply once 120 days before it expires. However, you have to make the H4 follow. Whenever you move from company A to company B, you need to file an I-539 anytime. The reason for that, if company A, once you leave company A cancels your H1, the H4 will get cut off. If the H4 gets cut off, the EAD gets cut off. So as long as you keep the flow of the H4, the EAD will follow it.
Okay. But in general, they don't care if someone applies H4 EAD in the span of 6 months, right?
It can take... you mean 6 months for the H4 to get approved, or the EAD?
Yeah, like for example, as I mentioned in my current scenario, she has to first apply, because her EAD expires 2019 June, right? So she has to apply somewhere in Feb for extending till 2020 for the new H4, and then when my H1 extends, she needs to again apply her H4, right?
Yeah, you will have to, because you will get only up. She will get only up to the time of your H1 first. So
yes. But that should be okay there's no issue, right? As long as legal. Okay.
No, there's no issue. That's the normal process.
Okay. So second question
you can do is, another trick you can do is that the first one you apply for extension, the next one, as soon as you get an extension, make her travel, get a stamp, come back, then you don't have to wait again. She'll get a new H4 with your new extension date. Okay?
Oh, I see. Okay. And the second quick question is, I know the EB2, like my EB2 date is like 2010, mid of 2010. Do you think, I know that recently it moved to March 2009, right? Do you think in this year it will probably move faster, or it is going to go back, or Any
I think
estimates?
it will move faster. What has happened, a lot of people shifted to EB1 and they might have abandoned the EB2, but that's not really a good reason, but because it doesn't really follow some kind of logic. But we are thinking that a lot of people didn't apply. If you look at EB3, EB3 is having another jump too. So it's kind of evening out. So my hope is that it might reach around probably by the end of this year, we might reach end of 2009. Unless there's a return.
Okay, I see.
So
and next year it might go to 2010. Okay.
Yes, let's hope so. Okay.
Okay, thanks a lot. Really appreciate. Thanks a lot.
Good luck to you. Thank you. Let me take another caller, Michael. Cham. Hi, Pancham.
Hello.
Hello.
Hi, this is Pancham Sharma from New Jersey.
Oh, hi, New Jersey. Hi from California.
Yeah, I have some questions related to green card.
Yes.
Hello?
Yes, I'm listening to you. Go ahead.
Okay. Like my priority date is like in 2010, and I just wanted to know, like, if in some case, like, because there are so many things going on for H1 extensions, so if it's in case, like, in some scenario, if it's denied, then what will happen to my green card, which is in process?
Okay, very good question. I was going to talk about that. It doesn't get affected, okay? Just a denial on H1, remember, doesn't affect the green card. Even you go back to India, as long as your company doesn't decide to stop sponsoring you, you are fine. You can always use that. For example, let's say tomorrow you get denied, you say, you know what, I just go to India and wait for my green card. As long as the company doesn't cancel the I-140, as soon as the date becomes current, you can always come back here, maybe back on your H1, revive it, and then do your adjustment of status. It doesn't get affected. The only time it might get affected if there's some kind of fraud. If there's no fraud, you're pretty much safe. So don't worry about this point.
Okay, so maybe like I can transfer to my company in India, work from there, and once my green card date become current, I can come back and file for my 485, right?
Oh, yes. In Play Smart too, you can always come back also on L1A and file EB1C if you stay there 1 year and then borrow that price to get your green card. That's what I just did on one case. Okay.
And like on 485, they scheduled interviews now, right? So
most of the it's not difficult though. I got a couple of clients who just went. You just go over the application. The only time it will probably become difficult if the company has committed some kind of foul play or fault or fraud. If they put wrong information, etc., etc. But bottom line, it's not that difficult, and we can help you prepare for that. Don't worry. Okay?
Yeah, because we need some visa to come, like even for interview when my date become current.
No. Then you won't be able to. Okay, listen. For you to file for the adjustment of status, you will need to be here, right? And once you file it, you can also file, if your dates become current, you're filing it, you'll probably come on some kind of visa like H1 and everything, because you cannot file adjustment of status from there. You can only file it to National Visa Center. So if you file it to National Visa Center, not adjustment of status, then your interview with the US Embassy. But if you file it as an adjustment of status, you will probably also file for the advanced parole. So that will allow you to travel back and forth. So don't worry about that part. There are solutions for that. Just give a call if you need help on that. Okay?
Okay, sure. Thank you very much. You are like holding it. Yeah, great show.
Okay, thank you so much.
Yeah, cheers.
Let me give the phone number for our office, 510-742-5887. Let me continue talking about those memos, because those memos are really scaring people, as many things that are happening here in the country. So I highly recommend that you make sure that, for example, few tips. 6 months before your H1 expires, file it. File your extension. And not only file your extension, make sure you file it under premium. Okay? The reason we are saying that is if the case gets denied without RFE, because there might not be an RFE, What happens next, you at least have a chance to refile it. Okay? So first rule of thumb, file any extension or transfer within 6 months before your I-94 expires. Very important. Second rule, if you're filing a transfer, make sure it's approved before you move to the company. Don't count on it to be approved because you're filing with a good company or not anymore. So file it under premium, get it approved, then you move to company. Third rule, make sure when your attorney is preparing the visa itself, they are preparing it with all the data that is there. And client letter, if you have if you're putting a job level 2, be very careful, etc., etc. So you need to make sure that it's a one-time deal. It's filed. You won't get a second chance now with no RFE if they apply that rule. And that doesn't mean all cases will not get RFE. All they say they will reserve the right to issue an RFE or not, which basically means they are not going to issue it. So those 3 tips are very important. 6 months before, which is your deadline anyway, you can file. That's the earliest. Number 2, if you're transferring, make sure it's approved. And number 3, prepare the case properly. And that's where an experienced lawyer makes a difference. But even experienced lawyers can make mistakes. That doesn't mean we are infallible to mistakes. So I highly recommend that you make sure things are done properly. Now, for the RFE situation, it's not the end of the world. We can deal with that. Now, then the other thing that people are asking me, how much time do you have once it's denied for them to issue the NTA? Well, we don't know. This is a problem. 2 things give us an indication. Number 1, now, USCIS themselves, the officers will be allowed to issue NTA, which is very not the normal way because they used to run it by eyes, etc., etc. Now they will be issuing it. That means if you get an officer who knows, hey, this person already lost status and the case got denied, so what will happen? They will quickly go ahead. They can issue the NTA. And once the NTA reaches you, then we have a problem. You will need the court permission to leave the country or fight your case in front of court. And most people will not be willing to do that, and it's costly and it's a headache. So just be careful now. Unfortunately, things are not that easy that they used to be. And it's not that difficult either. It's just a matter of being disciplined and make sure that the company who's filing for you, which is filing for you, know what they're doing, and that becomes the major issue now. And the thing that I will recommend people to do is to make sure that they have an end client letter, at least, not at least now, without the end client letter, especially if you're working with a consulting company, you want to have this. Without this, you're going to face some really deep trouble. So bottom line, ladies and gentlemen, all those things are happening. And of course, many other things are happening, not in immigration. And you heard about it, Trump meeting with Putin, and all the stuff now is backfiring, Congress, that and that. Well, for those who are citizens here, please vote. Please, 2018, there's an election coming. Don't ignore the election, because there are many people counting on you. If you're a citizen, please vote. So I highly recommend you do that. And I'm not telling you who to vote for, but you know who I'm talking about, but make sure you vote. Let me take another caller, Michael. This is Shabra. You're live in here. Hello. Hello.
Hi, Shah. This is Sandeep. I had a question about what you said earlier. So you mentioned that make sure that it's a one-time deal when your application goes for H-1B. So I'm is about to apply H-1B extension for me on base of 140 approved. My question was, what are the specific things that I can ask to make sure that they do it right the first time, right? If you can give me some pointers.
Okay. Yeah, that's a good question. One of the pointers I gave, of course, is to make sure if you're working for a consulting company that the end client letter is present. Number 2, make sure the LCA is properly done, no mistake on the code. Number 3, make sure that you meet all the issues of a specialty occupation, because that's a big thing they're using. And number 4, basically have the employer-employee relationship dealt with. So all the issues that you see on RFEs, you have to second guess it at the outset and prepare the case accordingly. That rule of IFE, by the way, is going to kick in around September 11th. So right now, if you're filing, you might not go through this issue. But down the road, it will be coming. But on the other tips, make sure it's filed under premium. Okay?
Okay. Rule of what did you say? Sorry, I didn't catch that. Rule of RFE?
I'm sorry? I didn't hear.
Did you say rule of RFE? Sorry, I didn't get what rule you mentioned just now.
The RFE memo, the one I was talking about, where there will be no RFE, will kick in on September 11th. So in your case, that rule might not apply to you yet, because you're planning to file right away, right? So if you filed in a premium, you still might get an RFE, okay?
Oh, okay, the rule where they won't do an RFE anymore and just deny if it's not filed the first time. Okay, right the first time. Okay.
Yeah, exactly. That will kind of kick in on September.
Got it,
okay?
Got it.
Okay.
Okay, so the end client letter and the employee-employer relationship, did you say?
And the specialty occupation. Make sure they put you in a position that will qualify you. Okay?
Okay, thank you so much.
Next week, maybe I'll go over the list of the positions that is a no-no, like computer system analyst, computer programmer, and stuff like that. And if you try those, you need at least level 4. So it's tricky. You need to be very careful. Okay?
Okay. Thank you so much.
Okay. Good luck to you. So, ladies and gentlemen, we were talking about the memo. I had a lot of callers today, and I wanted to thank all the callers. It's really thoughtful of you, and we have callers all over the U.S. It's not just, and I know we have listeners not only in the U.S., but I have listeners also who write to me sometimes from India, Pakistan, China, Fiji, you name it, even. And I really appreciate that you've been faithful to the show, and you've always been faithful, and we will continue as much as we can, God permits, and of course with the support of Michael, Radio Zindagi, and all the good people, we might be able to kind of bring some sense to what's happening right now. The truth is that there will be a lot of difficulties, so you need to be ready for those. As I mentioned before, I did a posting on Facebook one time. I said it's going to get worse before it gets better. Well, it's going to get worse before it gets better. So I'm going to say that again because we're going to see some major changes. As for the H4 EAD, I get a lot of calls. Well, we were hoping to at least know what's going on, but it seems like there is no real news as far as I know. So no news seems to be good news. Well, not great news, but still good news. So it doesn't seem they are really focusing on taking it away. But we'll have to wait and see. With those guys, suddenly you can get anything. So, ladies and gentlemen, I wanted to mention that. So I'm going to change gear a little bit and talk about something else that a lot of people are calling us about now because they're leaving the country. Like our callers earlier, they would like to be at least less stressed and live their life. So many of them are going back and wait on the I-140 to be current, and in the meantime work for their companies remotely. But in the meantime, they have debts, credit cards, home mortgage, you name it, and since once they leave, the salary will not really be the same. Many of them find it difficult to pay their credit cards, their bills, well, not their old bills, but many things. So one of the things that we offer is called debt settlement. We can kind of settle those credit cards. Let's say you use your credit card for like $10,000, $20,000, and then you're leaving, and you can't afford to pay it because of the situation. We can negotiate with the bank and reduce that to a fraction of its value and pay them and get it over. That doesn't mean your credit is protected. Well, once you pay them, it's settled. You can rebuild it later, but at least you don't have a headache on your head so that when you come back, you don't have to face any kind of issues. So it is what we call debt settlement, and you can check the blog, yourdebtsettlementattorney.com, yourdebtsettlementattorney.com. We can help you. It doesn't mean that you have to go for us to do that. Any kind of hardship, for example, you lost your job, you lost your property, you have an addition in the family, etc., we can do a debt settlement. Give us a call, 510-742-5887, 510-742-5887. Website to check is yourdebtsettlementattorney.com. That's for debt settlement. And of course, for our main website, attorneyonair.com or piralilaw.com, it goes on the same. attorneyonair.com. And please subscribe to our YouTube channel, youtube.com/Shah Pirali Law, SHAHPERALLYLAW.com. It's very important that you subscribe to this. The reason for that is that I try my best to update things, and since it's kind of busy time now, I don't really write articles. All I do is that I upload an update on YouTube, and that's the best way to get the updates. And I try my I think okay, so I apologize for that. So ladies and gentlemen, we were covering about a lot of things today. I will go back now to recapping what I said. I won't be able to take more callers now, so if you want to call our office, 510-742-5887, 510-742-5887. The topic of today, of course, are those two infamous memos, I should call it. Number one, issued, I think, in June 29, the one which talks about the NTA, any denial, people will be placed in deportation. And secondly, we have this memo that came out on July 13th, and basically talking about the situation of no RFEs and no notice of intent to deny. And for those who have not heard me earlier, you can go back to the show. I will post it on the YouTube channel by tomorrow or the day after, and you will hear the tips I kind of gave. I'm just going to recap it quickly. Number one, make sure you file within 6 months before your visa expires or before you transfer. Second, if you're transferring, make sure you get an approval before you move. And number three, make sure it's prepared properly. And number four, make sure that you don't move to the. Oh, I already mentioned that. But number four, make sure that it is done in a way where all the issues of an H-1B as if there was an RFE. So it is very, very important that, ladies and gentlemen, that you actually make sure that all those requirements are met. And even if you meet all of them, be ready that you will have to leave. You will get a denial. Excuse me. Now, the thing that is very important, what happens if you get a denial? I used to tell people, which is still the law, but it's not really good now. Within 180 days, as long as you leave, you're good, right? Because you don't get affected when you come back. So in this case, I recommend people to pretty much leave ASAP. So that's where it's kind of unfair, because just to wrap up, especially if you have kids and things like that, you will want to take your time to leave, at least 30 days or so. But if they really want to be quote-unquote mean, we won't have those 30 days. So as soon as you're filing something, especially if you know there are weaknesses in the case, for example, the company is not strong, your end client letter is not strong, etc., I will recommend that you get ready to leave. Because the problem, if you don't leave and they put you in deportation, like I mentioned earlier, you are going to go through a hard time to even leave. And without leaving, you won't be able to reset your visa. So it is not a good idea. So when you leave, what happens next? Let's say you leave on time, perfect. When you go there, then your company can still file your extension, get it approved, then you go and get a stamp. If you don't have a stamp on your passport, then you can come back, hopefully, and things will work out. But until then, the order is to leave as soon as you get a denial. Now, when I say as soon as you get a denial, that doesn't mean if you have your case is still, for example, let's say you have a 994 till December of this year. You file an extension under premium, and let's say it gets denied in September. Well, you don't have to leave because you still have till December. So what you can do, you can refile. That's the reason I say keep the 6-month margin, because that's the earliest you can file. So make sure that your employer understands that, and if you're an employer, make sure you do that for your candidates, because if you don't, you're going to lose them. And it will be a big mess on you and them. So I recommend, if you need help, please give us a call at the office, 510-742-5887. Now, the issue with the RFE, one of the things we recommend now is to prepare the case well. There's no way you can prepare a case 100% well, especially there's a lot of discretionary power. There's another option to deal with H-1B denial, by the way, which most people don't want to take, is to sue them in federal court. I've seen many cases where people do win in federal court, but it's costly, timely, and if you lose, then you are accruing unlawful presence. And that's the biggest issue, to file that in federal court. So I'm just mentioning it here, but it's not something that I don't handle those, but I know how to handle them, I just don't. But it's an option that is there sometimes. As for filing what we call a motion to reopen, or what they call an appeal kind of, there's no appeal, it's called a motion to reopen or motion to reconsider. If you file it, it doesn't grant you any kind of period of stay. That means they can still put you in deportation. So I will recommend, if you want to file that, still leave and wait on it, and then let's see what happens next. So it is at this point becoming very stressful, and I know that, but we are by your side. We'll try our best to help you. If you want a second opinion, even you have a lawyer, feel free to call our office, 510-742-5887, and check our website, attorneyonair.com, attorneyonair.com, and of course, as for those leaving, if they want to settle their debts, please also give us a call, 510-742-5887. We are talking about credit card debt or second mortgages, etc. Feel free to reach out. If we can help you, we will help you. And check yourdebtsettlementattorney.com, yourdebtsettlementattorney.com. Thank you, Michael. Thank you, Radio Zindagi. We will be back next week. And like I said, anything I mentioned today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any question. So I'll let Amit continue, and the same show will be replaying midnight on Friday. Thank you, ladies and gentlemen. We'll be back next week. Take care.